Utterances by its senior member in provincial MEC Faith Mazibuko are unfortunate, regretful and embarrassing, and that matter will be referred to the party's integrity committee. Now, whilst her actions of the MEC are quite clear from the recording, a question that is being raised is, what's the legality of staff recording meetings with their bosses? Well, let's ask labour law expert Stephen Ramahoko, who's in our Pretoria studios. Thanks very much for joining us. Good afternoon to you. This is an interesting case, and I think the focus, of course, is on what was actually said, that the MEC has apologised. But let's step away a little bit from that and talk generally about when staff record conversations that they have with their bosses. Is that legal?
Good afternoon, Peter, and thanks for having me here. Good afternoon to the viewers as well. Let me commence by saying that as a constitutional democracy, we are founded on principles of human dignity, equality, and freedom. And the Constitution further on Section 14 provides that everyone has the right to privacy and not to have their private conversation infringed. So when you look at that, you realize that there is a higher degree or standard of behavior expected of people in interfering or infringing communication. Further, to give effect to this constitutional right, the country has adopted legislation called Regulation of Interception of Communication and Provision of Communication-Related Information Act 70 of 2002. This clearly makes it illegal to record private conversations. However, the legislation seems to have anticipated circumstances wherein the participants or other people would have interest in recording the conversations. And these are called exceptions. So the general principle is that you cannot record the private conversations. Those exceptions as provided for in the law are the following. The first one is that you need to be a party to the communication, or you have the consent, the written consent of one of the parties to the communication.
All right, so
or when the recording.
Just hang on. So are you saying that if I am in the conversation, I don't need to get permission of the other person if I'm part of that communication?
Yes, definitely. That is definitely an exception.
Okay. All right.
Yes.
But can I then use a recording I'm party to? So I'm talking to you now. I record that conversation. You don't know that I'm recording you, but I then use the things that you've said in that conversation without your consent. Yes.
Let me indicate that, the general principle is that it is unlawful, but this would be an exceptional circumstances, provided that you also participate in the communication or conversation. If you just record it and you cause the other person or party to say things and you are not aware in the recording, therefore the recording would not be accepted as evidence anywhere. It will not comply or meet the standard to be declared an exception.
All right, so if you can't use it as evidence, the reverse must be true, in that I can maybe ask for some kind of compensation for having my rights violated if I publish that conversation.
Yes, my view is that, Peter, when your rights are trampled upon, you have the right to enforce your right, to protect your constitutional right, and therefore you can take issue with the party who violated your right.
All right, so what if the subject of that conversation reveals some criminality or some wrongdoing? Does that then become an exception?
Let me just indicate that if it has to be escalated to a criminal offense, or there is a level of criminality, you are in violation of the human right by recording the conversation. However, the court cannot disregard evidence that is obtained in order to enforce integrity in how the state deals with its affairs.
So let's assume that this conversation that the MEC had with her senior managers was recorded by a staff member. Can the MEC take action against that individual for recording this conversation?
Let me just indicate that the MEC can enforce her rights to privacy, provided the recording party does not participate in the conversation. Okay. So, although it is not yet a settled law in our country, but we do have a case law that was decided using a similar provision in the previous act that was that preceded the RICA Act, and that is State versus Kitson. So in that particular judgment, Judge Cameron held that the purpose of the act was to protect communications from eavesdroppers and not from participants. So if a participant is not just recording but is actively involved in the conversation, then the exception kicks in, and therefore whatever evidence is obtained there can be used provided authenticity thereof is verified by the court or accepted or admitted by court.
All right, we're going to have to leave it there, Mr. Ramahoko, but thanks very much indeed for giving us some insights on this issue. And I guess overall the message really is err on the side of caution. If you're going to record a conversation, either warn the person that's a part of that conversation that you are recording it, and you must be party to that conversation for you to be able to use any of the contents in that. So in other words, you can't just leave your recorder on somebody's desk, walk out of the room and record what they're saying and try and use that stuff. You've got to be part of that conversation. But clearly, I think you'd best want to get some legal advice just in case it comes back on you. Right, so we're going to take a quick break.